Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Today I thought I'd talk about what is, I think, every lawyer's least favorite subject, which is what happens when you lose. Well, I haven't had a great deal of experience at losing. I've certainly lost a few cases, but by the same token, there are many different ways to lose a case. Sometimes you can win and still lose. For example, one of the first cases that I was part of the team trying, we recovered a verdict for the client, but because the defense argued that the woman's injury was at least as much related to smoking as it was to malpractice, that, if she didn't value her life, why should you? And they wound up giving her about 1 year's worth of her salary, or giving her decedents about 1 year's worth of her salary, which was a terrible and egregious loss. And we appealed it on the basis of voir dire, and we actually didn't win on the appeal, but later on, the court reversed the case where we lost. So in the end, we were right, but nobody realized it at the time. These things happen. In another instance, I lost because I was supposed to lose. I represented a fellow who was charged with promoting prostitution. The reason he was convicted is because he was very guilty. No question about it. I had cross-examined one of the state's witnesses and proved that she was a liar. And one of the jurors told me later on, "Oh yeah, you proved that she was a liar, but she wasn't lying about him." And I think that probably was a lesson that I learned a lot from, in that you can prove up a lot of irrelevant things in a case involving a jury, and a jury can say, yeah, she's a liar, but she's not lying about this. It is possible to lose a case, and when you lose a case, all kinds of different things happen. The last time I lost a case, it was a nursing home case, and I felt very, very badly for the clients. It had taken us 9 years to get into court. We'd been to the Court of Appeals once, we'd been to the Supreme Court once, and then it sat around bouncing from judge to judge at the circuit court level for about 6 years after that. It was a very, very difficult case. I knew it was difficult when I took it, but I believed in the family. I believed that what they really wanted was to do justice for their mom. Unfortunately, I had some opposing counsel who pulled out every dirty trick in the book. They were not very gentlemanly, and as a result of that, they hired an expert who came in and lied, and not just a little. I mean, we're not talking about little white lies here. We're talking about, big black whoppers. I think the jury bought into it, and we wound up losing that case. It was an awful experience for me. I was mad for a good 3 weeks after that. Every time I thought about that case, I was mad, because I knew what really happened. I knew what the rules really were, and I thought the jury had been bamboozled, but we had already been to the Supreme Court once, we'd already been to the Court of Appeals once, and the family just didn't have any stomach for going back and having a second try at it. And I was pretty upset about it, and my boss, who was a distinguished trial lawyer, had handled literally hundreds of medical negligence cases. He told me, when you've done your best and you get the result and you lose, what happens is you've filled up that bathtub with all the different facts of the case, and you've put every last ounce of what you were working on into that bathtub, and now the water's cold, you've lost. He said, you got to drain the bathtub and move on. And boy, that's a hard concept when you have really, really worked hard on something, to have to be told, look, you're just going to have to let it go. Because that's not the way the world is supposed to work, right? But then again, if the world worked the way the world is supposed to work, non-stick pans would actually be non-stick. So we know that's not the case. It's a tough situation to be in. Now you look at the Crumbly case, the two Crumbly cases, and you analyze what it's like to lose at that level. And you're on a national stage, you're representing your clients. I don't care who you are. You can be Clarence Darrow reincarnated, and you still make mistakes at trial. You still ask questions you shouldn't ask. You still fail to object when you should. As I say, these things just happen. So the very first thing you do after you have finished the trial and you've gotten a verdict that goes against you is you file a motion for new trial. You set out every single error you believe the judge committed. Errors admitting evidence, errors failing to strike testimony, errors giving the wrong jury instructions, errors shutting down your line of questioning because the judge feels that it's irrelevant, even though you prove that it is relevant. You set out all of these errors in a motion. And if you don't set out all of the errors, and then later on somebody says, hey, what about this? You either amend that motion within the time that you had to file it. And usually in Missouri, I think it's 15 days you have to file the motion for new trial. If you have a few days left, you can always amend. But if you have not, if it's gone past that point, then you have a really serious problem on your hands because you've now waived that error. So basically what you do is you look for the most significant error. And the most significant errors are errors of law. And they are the errors that are not subject to a discretionary standard. In a court of law, when the judge is ruling on evidence, for example, is this hearsay? Is it excluded by the hearsay rule? Is it saved by the hearsay exceptions? Any of these things, that's a discretionary act. In essence, the judge has the discretion to make that call. And the only time that a court is going to reverse a decision on the basis of an evidentiary error is when, first of all, the error is egregious. In other words, the judge abused his discretion. He acted arbitrarily or capriciously. His ruling shocks the conscience. It's like no other judge would ever do this. In Missouri, the rule is that if it's discretionary like that, an abuse of discretion happens only when reasonable people could not disagree. So that's a pretty high standard to reach. And if reasonable people could disagree about whether to admit that evidence, well, you are not going to win on appeal on that point. But even if you win on that appeal point, it has to be central to the verdict. It has to be something that so upset the balance of the trial that it caused an erroneous rendition of verdict. And a lot of times what happens is the court said, yes, the trial court erred. It should not have admitted this evidence from the defendant of a particular medication that the patient was on. Shouldn't have admitted that evidence. But having reviewed the entirety of the case, we find under the totality of the circumstances here that it's harmless error. In other words, yeah, the judge shouldn't have done that, but look, you were never going to win this case anyway.
Now, here is an interesting case from the state of Missouri that talks about the harmless error rule. And this involves a cat fight between two women, both of whom were called by the same man to come pick him up and go get food with him. He called one after the other because the first one didn't answer in time. As a result, he had two women, both aiming to pick up the same man, who got into a fight in his front yard. One of them wound up stabbing the other, and as a result was convicted of aggravated assault and armed criminal action because she stabbed this woman with a pink knife she had clipped to her purse. So the issue here is, that was addressed in point 3 of this opinion, is whether or not she should have had counsel appointed at the bail hearing stage. And this is a really good example of harmless error. The court says, even if bail hearings are critical stages at which an accused is constitutionally entitled to the presence of counsel, the absence of counsel at the defendant's initial bail hearing stage and at the defendant's detention review was harmless error and does not justify reversal. A harmless error analysis applies where counsel was absent at a critical stage of a criminal proceeding, but the particular event during which the defendant was unrepresented did not taint the entire prosecution. Even if the defendant's bail hearing and the detention review were held 5 days later were critical stages, the absence of counsel at those hearings constituted harmless error which can't justify reversal of the defendant's convictions. And of course, that makes sense because whether or not she was granted bail has absolutely no impact whatsoever on whether she should be convicted of the crime of aggravated assault and armed criminal action. And obviously, the Western District here said that they felt she should. As a little footnote to this, however, the Western District essentially forwarded this case on to the state Supreme Court to get a reading from the state Supreme Court about whether people need to have counsel appointed at the bail hearing. So the court did the right thing, even though it didn't agree with the defendant's contentions.
So those sorts of errors are really, really problematic on appeal. You argue them, but you always put them toward the back of the brief and not at the front. Before you ever get to writing the brief, you have to develop the record. And the record comes in two forms. The first thing that happens is you have to get the trial record of all of the pleadings and motions and decisions that the trial court made, all of the orders, that sort of thing. You know, if it relates to a continuance, you have to get the order for the continuance. All these things. That's the paper record, and it's called the legal file. And then you have to get the transcript, and that's where the judge is on the record at every point in time in the trial, every point in time in trial that matters, which usually starts with the voir dire and ends with the judge thanking the jury. You get all of that, and it can run to thousands of pages in a long trial. And because of that, it often takes 3 to 4 to 5 months to get the trial transcript finished. And that's because during the daylight hours, the court reporter is in there in the judge's chambers, and she's taking everything down. And then, after she goes home, she sits down at her computer and runs through the tape of the trial and does 30 or 40 pages of the trial transcript every night, shuts her computer down, and then goes on, and repeats that day after day until the trial transcript is done. And in case you were wondering, yes, she gets paid extra for what she does at home in transcribing the trial transcript. She will give you usually an estimate of what the trial transcript is going to cost. If it's $1,500, then you pay her a deposit of $1,500. And it turns out to be more. Usually it can only be about 10% more, but you're going to wind up paying for the transcript before you ever get to the point where you're briefing, because you're going to have to refer to the parts of the transcript where things went wrong. For example, in the video I did the other day with Mr. Steele in the YSL trial, you have him making an argument in front of the judge about why this evidence should not be admitted, or in his case, he was trying to get something in on a cross-examination, and the question was whether or not there was a foundation for it. And so all of that happened, and that colloquy would be preserved in that trial probably at page 10,021, because they've been going at that for a long time. But that's where he would go. He would pull that colloquy out, and he would put it into his brief. And a brief usually contains multiple parts. The first thing it starts off with usually is a jurisdictional statement, meaning this is why the appellate court has jurisdiction. Then it goes to a statement of the case or a statement of facts, where you go through all of the different things that happened in the pretrial and trial. And then after that, you go into the actual argument section. And in Missouri, we have something called points relied on. And here is an example of a point relied on. The trial court erred in allowing Dr. Gournay to be cross-examined on who was responsible for the payment of Mr. Denton's medical bills because it injected a false issue into the case, and that Dr. Gournay could not explain why the description legal was in a bill generated by an entity he did not control, and his answers lacked foundation. Essentially, a roadmap to the point on appeal. And you will usually list the first 3 or 4 cases that are tremendously applicable inside that point. And then A lot of lawyers use what's called an IRAC method: issue, rule, analysis, conclusion. I don't do that. I start with usually the conclusion. Trial court erred. It was an egregious error. Here's what the error is. And then I go to the facts. This is what happened. These are the reasons that things happened the way they did. Then I go to the legal rule. This is what establishes hearsay. Then I go to the analysis. This is why it's hearsay. This is what courts have said in similar situations. And this is where I bring in all of my authority. And then at the end, I bring back the conclusion again. It was an egregious error, and the court should reverse the verdict. And I do that with every single issue I'm going to raise. Now, what makes it especially challenging is that you're going to have word limits. Now, you can get a court to waive word limits in certain cases. For example, a death penalty case, a lot of times they will grant you some extra words. But for the most part, you are stuck with a certain number of words or a certain number of pages. The Colorado Court of Appeals has a ridiculous limit of like 25 pages for a civil appeal, which is crazy to me. But that's their rules, and you have to get your argument made. I mean, it certainly causes you to make the best argument you can in the shortest period of time, and that's why it's important to be a good legal writer in a case or in a state like that. But judges have to read, particularly appellate judges, have to read a whole lot of paper in the course of a day, and they generally appreciate both a roadmap and then a few cases, and a lot of times they will look at a few cases and then they will analyze the brief. Those are the things that go into an appellate brief, and then the other side files their brief in opposition, and, again, it wasn't our dog. It didn't bite him. If it did bite him, it was because he was harassing him, and she wasn't hurt anyway. All of these things come in the appellate brief from the other side, and then I get a reply, and I say, they're wrong, and here's why they're wrong. That appellate brief is about 25% of the number of words or the number of pages that you get in the original opening brief. At the end of that, it then goes up to the court, and they decide whether or not you're going to get oral argument. If they grant oral argument, then you will have anywhere from 10 to 30 minutes to argue your case, depending on what level of court you are at. In the Supreme Court, I usually get 20 to 25 minutes. I very rarely take that long. I try to hit the high points and sit down because the judges appreciate that. If you have a strong case, you can do that. I always try to answer all of the questions that come to me, and then I sit down. And then I let the other guy go and do what he has to do. Then I get a reply. I get up and I stand up and point out the errors that they made. And then I sit down, and then you wait. In Missouri, the wait is usually 2 to 3 months. Sometimes it can be 6 months. In a real outlier, it can be 9 or 10 months. But eventually you will get an order from the Court of Appeals, and they'll either grant your appeal or they'll deny your appeal, and they will write an opinion. That's what happens when you lose. It is always much better to win. That's what I have for you today. Thank you so much for watching. If you have any questions, please leave them in the comments down below. Or if you'd like, you can email me at the address above. Like, share, subscribe, all those things. I will tell you that I would love to have you subscribe if you find this content interesting, but I always try to put that at the end of the video instead of at the beginning. I think a lot of people just think you'll forget by the time you get here, and I know that according to YouTube, that's the best practice to front load that, but I don't do that because how in the world would you know whether you want to subscribe until you've heard the content? Hopefully you found this interesting and useful. If you have the opportunity today, do something nice for someone. Overtip a waitress, or, pick something up off the ground that somebody dropped and didn't realize they dropped. All of those things are wonderful ways that you can make somebody else's life better and somebody's day better. And when you make someone else's day better, inevitably you make your day better. Have a great day, and then tomorrow, come back here and catch me down at the beach.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.